No, not at all.
Is it
Um,
stressing you out at all?
no.
Okay,
And
just
we're live.
checking.
It's Monday, May 17th, 5:02 p.m. Eastern Time. It is what, 3 p.m. 3:02 p.m. No,
4:02 p.m. in
4:02
Austin.
p.m.
Only one of Texas's 269 counties is in the Mountain Time Zone.
Oh, I did not know that.
Just
So,
El Paso.
oh, okay. So is it 4?
It is 4.
Oh, nice. Okay. It's 4:02 p.m.
And we hear there's torrential downpours.
And there's torrential downpours, and you can see how well traveled Steve Vladeck is, and how much he likes to make me mad by purposely saying the 1986 Mets. I will do you one better, Steve. One of the In Lieu of Fun fans sent me this picture.
That's what we got my dad for his 40th birthday.
Yes. So the 1986, as a long-suffering Red Sox fan for most of my childhood, that was the 1986 Mets we were not allowed to mention. There's pictures of me in ALCS 1986 t-shirt, but that was, we don't talk about that anymore. Anyways, we're not allowed to have fun anymore, but we are allowed to have kind of a great round robin today of, not kind of, but actually a great round robin today of Supreme Court experts and con law experts to talk us through the cert petitions that were granted and the decisions that came down.
Leah's here.
Oh, and Steve, oh, that's great because she had no internet before. So I am glad that she is here now.
Well, I detect her presence.
We have Steve Vladeck from the University of Texas, Hook'em. And we have Leah Litman coming in from the University of Michigan Law School. And she will be here in a second. And we might have Kate Shaw from Cardozo Law School to join us before softball practice. Unclear.
Hello, Leah.
Hello. I think Kate will be joining from softball practice if she's able to join, which I'm not sure is actually going to happen.
It would be kind of.
I would rather be at softball practice. No offense. I mean, just.
Do you want to know what the Second Circuit softball team name was? Learned Gloves.
Oh, that's pretty good, actually.
Come on, Leah, really? Wow, that's like
I think that's. I think we gotta give Chief Judge Katzman at the time credit for that. That's a good name for I think that's pretty witty. For those of you who have been waiting with bated breath for a Brood 10 update, on the walk today, I saw literally thousands and thousands of cicada shells. They are here. They are risen, you might say. They are in every tree now. And I welcome our Brood 10 insect overlords. They have not started making noise yet.
That'll be in the moment.
It's going to be exciting.
So today, kind of a crazy day, some insane cert news. And I was very confused by some of the decisions and didn't really have the background to unpack the significance of some of the decisions that came down. But which do you guys want to kind of dig into first? We can take the obvious Mississippi abortion 15-week ban.
This is a tough call. I'm curious which one Leah finds more horrifying: the majority opinion in Edwards or the grant in Dobbs. And I don't have a good feel of what the answer is.
Yeah.
Okay, but wait, walk us through for those members of the audience who have not followed the news today. What are the majority opinion and the cert grant?
Yep.
Leah, you want me to take one? You take the other?
Sure. You pick.
Oh, gosh, I picked. All right. Well, I'm going to take the one that I think, Leah knows more than I do about both of these things. So I'm just going to dive in on the majority opinion in Edwards and let Leah talk about Dobbs. So Edwards versus Van Noy is, at least on the surface, this very, very technical case about whether the decision the Supreme Court made last term in Ramos versus Louisiana, where the court said that the constitutional right to a unanimous verdict in criminal cases applies to states. That was last term. right, to the last two states, and at that point, one state that still didn't have unanimous juries, although, of course, the military still does not have unanimous juries. And so the question in Edwards is, does that apply retroactively? Meaning, if you are a prisoner who was convicted in Louisiana or Oregon by a non-unanimous jury, and your direct appeal has gone final, as most of these prisoners' direct appeals have, can you enforce this new rule retroactively through habeas? And the Supreme Court has, since 1989, had this basically sort of this general rule that new rules are not retroactively enforceable through habeas, and we should talk a bit more about that, unless they are substantive. So like when the Supreme Court says you can't execute juveniles, right, that's enforceable through habeas, or unless they are watershed rules of criminal procedure, of which the only example the Supreme Court has ever given is Gideon, and the right to be represented by counsel, even if you can't
Gideon
afford
v.
it.
Wainwright, which is famously the case that grants people a Sixth Amendment right to counsel.
Even if you can't afford it, right? That you have the right to appointed counsel. And what the court did today, so one part of Edwards is not surprising. I don't think any of us expected this court to hold that Ramos was retroactive. But Justice Kavanaugh decided that that wasn't enough for one day's work, and actually said, in fact, we're just going to never have watershed rules anymore. And so the majority opinion holds that there's just no longer a category called watershed rules that can be retroactively enforced. In other words, that anytime the Supreme Court hands down a new decision that creates a new rule of procedure in criminal cases, no one whose direct appeal has gone final will ever be allowed to benefit from that rule in a federal habeas petition. And that is such a remarkable and remarkably unnecessary holding, given that all they had to say was that Ramos itself was not retroactive. So, that would have been enough, especially for Fed courts nerds like Leah and me on any day. And that came, of course, about 40 minutes after they granted cert in Dobbs.
Okay, so really quickly, I just want to ask something really to like kind of
wait. Let's get a full sweep.
Okay,
of the
but
day before we go back and dive in on the details.
But I just have a really small procedural point with that. So this is like they went broad when they could have gone narrow, which is like just as a big point, like probably the opposite of how most of the Supreme Court has gone in like the last 2 decades.
But so I think there's a story here, Kate, and I suspect that Dobbs is part of this, which is the reason why the Supreme Court spent most of the last 10 or 15 years not going broad, except when it went broad, was because of the moderating, not moderate influence of Leah's former boss, Justice Kennedy. And so I think today is both of these headlines, both the Edwards decision and the Dobbs grant, this is not a shy court. And they've got the votes. They know they have the votes. They're not, the only remaining speed bump was John Roberts. And now that Roberts is no longer the median vote, even, on this court, right, that speed bump is gone. So, I think that the point is they're going broad, Kate, because they can go broad.
Yes.
Even in cases where there's no need or justification for doing so.
I wanted to set that question up. Sorry to distract, but I wanted to set that question up before Leah started talking, knowing Leah's expertise in this exact area and kind of to frame the cert petition from Mississippi. So do you want to talk about that, Leah?
Yeah, so Dobbs is a case that the court granted this morning, and so the case will be heard next term, and it will be the first abortion case that the court is hearing for argument since Justice Barrett was confirmed and Justice Ginsburg passed away. The case involves a challenge to Mississippi's ban on abortion after 15 weeks of pregnancy. Because that ban prohibits women from obtaining abortions at some points before viability, it falls squarely within the teeth of what Planned Parenthood versus Casey described as the core holding of Roe versus Wade. So Roe versus Wade is the 1973 decision that famously held women have a constitutional right to an abortion. Planned Parenthood versus Casey is the 1992 decision that declined an invitation to overrule Roe and said they were retaining the core holding of Roe, which they said was states can't impose an undue burden on women seeking access to abortion. Now, for regulations that are short of a ban, let's say a waiting period or an ultrasound requirement, there are sometimes difficult questions about whether those laws rise to the level of an undue burden. But Casey underscored that, in no uncertain terms, an undue burden meant that before viability, that is before the point at which a fetus can survive outside the womb, states cannot prohibit women from obtaining abortions. So this Mississippi statute flatly prohibits women from obtaining abortions for points before viability. And so the question that the court agreed to consider is whether, the Constitution actually prevents states from prohibiting abortions at all points during viability. The reason why that grant is significant is because, you can only uphold the Mississippi law if you outright overrule Roe and Casey, or if you jettison what has been, the core dividing line and tenet of the court's abortion jurisprudence, which is before viability, states can't impose undue burden or bans on abortions. After viability, they can. Option one is, again, overrule Roe and Casey. The Constitution doesn't restrict states' ability to regulate abortion. Option two is, viability is no longer a meaningful line, which means states could possibly outright prohibit or impose, more onerous obstacles before viability than they could before. In part because there has been a recent wave of restrictions on abortions, we have a bunch of lower court decisions that have enjoined bans on abortions after 6 weeks of pregnancy, bans on abortion after 10 weeks of pregnancy, bans on abortion after 12 weeks of pregnancy, so on and so forth. And those cases were super easy, again, because Casey had said in no uncertain terms, states can't ban abortion before viability. If you discard that, even if you don't say we're overruling Roe or Casey, all of a sudden, those cases become unclear, right? Because if states can prohibit some abortions before viability, what kinds of restrictions go too far and which ones don't. So this case is going to be huge. There is no way the court can rule for Mississippi without, substantially refashioning the law on abortion. The U.S. Court of Appeals for the Fifth Circuit, which is very conservative, agreed that this law is unconstitutional and, no question that it is unconstitutional under current law, but invited the court to overrule Casey in taking it. I don't think there's any reason to take this case except to uphold Mississippi's law. It's unclear what the rationale will be, but it's very significant.
So I have questions for you both. I want to start with you, Leah. It takes 4 votes to grant cert. It takes 5 to rule. Given John Roberts's behavior in the last such case, where, he said the passage of a year and the change of composition in the Supreme Court doesn't change the law, it seems to me the challengers to this law have at least a shot at getting Roberts's vote. That puts everything on. Since we presume that Amy Coney Barrett is not a gettable vote, it puts everything on Brett Kavanaugh. Is that fair?
I think that that's probably right. And Steve is laughing because I think he knows, this is my, personal bad place, right? Kristen Bell is out here screaming, this is the bad place. Yes, I think that is the position we are in. That being said, I think that the Louisiana case you were alluding to was in some ways easier for the challengers than this case is, because that case was the exact same law that the court had invalidated 4 years ago. And given that, right, there was just nothing for the Chief Justice to say with a straight face, without overruling Whole Woman's Health versus Hellerstedt. Whereas in this case, I see there are at least 2 options that I think would be bad lawyering. That is not a reasonable way to read the court's prior cases, but wouldn't actually require the court to uphold a law that they just invalidated 4 years before. And those two different ways are, one, well, yeah, Casey said that, but like wink, wink, nudge, nudge, it didn't like mean that, right? And like we don't read our prior opinions like we read statutes. And so Casey saying that bans on abortion before viability wasn't actually necessary to the holding. It was just like part of the opinion. That's one option. And then second is for, again, the court to say, we're not overruling it. We're just saying like viability isn't this magical on-off switch, and it's all an undue burden analysis. And so like go back down to the Court of Appeals and have them conduct an undue burden analysis. And like we all know what happens there, if they say that. So that's why I think in some ways the Louisiana case was easier for the challengers, and the chief was more gettable than he is here. I think he's still possibly gettable, but less so than with respect to the Louisiana case.
So do you think when you boil this down that this is presumptively a 4-4 with Kavanaugh as a hard get but a potential get? Or do you look at this as a fundamentally a 5-4 court from your perspective, the wrong direction, with Kavanaugh pushing it in the probable direction of a 6-3 court?
I don't know. I'm really not sure. I think that if I had to guess, it will be 6-3 for Mississippi.
What do you think, Steve?
I think it depends, because I think that there are going to be a couple of justices on the conservative side who will be perfectly happy, right, to do much more than what Leah suggested, right, to not just say, yeah, we said that about viability in case, but we didn't really mean it, right, but we actually, let's just admit, I think there are now probably at least 3 votes, and maybe 4, depending upon Barrett, for that proposition. And I think the question is just going to come down to whether they write separately and split the majority, or whether they all sign on to a narrow opinion, right, that makes the move Leah suggested. And if it's the latter, I could see the chief signing on to that for the reasons Leah suggests. I'll just say, this is the exact move that Casey made vis-a-vis Roe, right? That Casey took Roe and said it was about something fundamentally different than Roe itself had said it was about, right? And said the court, the troika in Casey, the Souter-Kennedy-O'Connor opinion, right, goes out of its way to sort of rewrite what Roe actually was. And I think that's what this smells like to me, right, is rewriting what Casey actually is. The only thing I would add to Leah's incredibly, I think, thorough and right on summary is, they didn't have to grant this, right? There was no circuit split. There was no, the lower court had struck down the statute. The Fifth Circuit had affirmed. This is a grant to reverse. And I think the question is just how.
This is precisely what the point that I wanted to drive home. So 2 things. One, I replied to you on Twitter, Steve, when you said something about how it was taking bites at the apple. And I was like, every fucking abortion case, but every abortion case has been taking a bite at Roe in some way and saying it's not about one thing, but it's about another. It's saying it's about it's about, changing the lines where we draw things. Casey, I was taught con law by someone who will go unnamed, but a woman who was clerk for O'Connor had helped draft it, and it was thought that she had saved abortion rights, and I was like what the hell? This is you wrote the slow funeral march for this for these. That's not saving anything, and this is exactly what we're seeing, and we've seen it over and over again. So I want to get into what the signaling of the powers that be. So Steve, you mentioned Kennedy being gone. Obviously, that changing the entire balance of the court and kind of the broad and narrow. The huge amount of kind of pro-life people that are on the court now and Catholic, and then the kind of the decision that they decide this was the first their first chance to take a case like this, and I feel like that's something directly out of the kind of the FedSoc playbook. What else were they going to do? So I mean, I don't know. Like, is it really that bad? Is it like, am I over?
Yes.
Yes.
Okay.
No,
I'm just
no.
like,
And,
am I reading the tea leaves and sounding conspiratorial?
But Kate, I would put this. I would put this in context with the Second Amendment case they took a couple weeks ago, right? I mean, there are hot button cases that the court would not take so long as Justice Kennedy was the median vote, that the court still wasn't really in a hurry to take when Chief Justice Roberts was the median vote, that they now seem perfectly willing to dive on top of. And I think that dovetails with, I mean, my particular bugaboo is the shadow docket. But that dovetails with what they're doing on the shadow docket, which is that they're issuing rulings that they never had the votes for before, and running sort of roughshod over procedural or normative constraints on their docket because they can, and because they see no one in a position to stop them. They are not intimidated by any of the court packing conversations. They are not scared of Congress. They have the votes, and I mean it's the inverse of the line in Hamilton, right? You don't have the votes. Well, they have the votes.
Yeah.
So I want to go back, Steve, to the substantive decision today, and with no commitment to it whatsoever, and knowing about it only what I've learned on this show, make you defend your skepticism about it a little bit.
Sure. I mean, so can I add a little bit of history first, because I think that might help.
Sure.
And I'm going to get too nerdy. So until the 80s, the Supreme Court took an approach. The question of when criminal defendants should be allowed to benefit from decisions that are made after their cases has been a vexing one for as long as we've had modern criminal procedure doctrine. Into the mid-1980s, the rule was the same whether your case was on direct appeal or it had gone final and now you were bringing a habeas petition, where not all rules were retroactive, but the rules that were retroactive could be enforced equally by two people tried on the same day, one of whose direct appeal is still pending and one of whose has gone final. That was the rule into the 80s. The Supreme Court changes the rule in a pair of decisions. The first is Griffith versus Kentucky in 1987. The second is Teague versus Lane in 89. Kate, back to your buddy O'Connor. And what the court does is they adopt the approach that Justice Harlan had argued for in a series of dissents during the Warren Court era, where all rules would be retroactively enforceable on direct appeal, no matter what the rule was. So expanding the rights of criminal defendants while their direct appeals were still pending, but that almost no rules would be retroactively enforceable through habeas, so that two people tried and convicted the same day would have two totally different outcomes, depending upon whose appeal took longer, and who stretched out the clock longer. And O'Connor justified this on the basis of the principles of finality and federalism. Finality because there has to be some point where cases are over, and federalism because that's how we show deference and respect to the states. Never mind that I'm not sure that tolerating constitutional violations is a proper justification for either of those things. So, Ben, the exceptions to Teague, right? There seems to be general agreement about the substantive exception, that people should be allowed to retroactively enforce new rules
if they
that
say
they're
it's
substantive.
unconstitutional to execute minors or people who were convicted when they're minors after you've been convicted, it applies to you.
Okay. So then the question is, which procedural rule should be retroactive? And there are three choices, right? The choices are all of them, right? Which of course the court would hate because it would sort of, Miranda can't be retroactive or else you're going to destroy the criminal justice system.
Well, the big issue is not Miranda, right? It's Apprendi.
Well, so Apprendi, Crawford, Ring, although I don't know. I want to play.
I
want to play on Ring.
Yeah.
But all right, so
affects a lot more people.
The problem is, right, there are three positions. One is they should all be retroactive, right? One is that none of them should be retroactive. And one is that some of them should be retroactive, but only if they're truly fundamental. And Harlan, right? Remember, this whole fakakta scheme, right, comes from Harlan. And Harlan was adamant.
You just used the term fakakta.
It was really good. It was a really good use. But keep going.
I just want to say, I'm just pointing that out to the non-Yiddish
So Harlan's whole
speakers
scheme, guys, is premised on
the
the existence of an exception for watershed rules of criminal procedure because those rules are not just rules that sort of create concerns about the fairness of cases from this day forth. They're rules that create fundamental concerns about whether trials in the past were fair, right? Rules that, like, it's hard to understand how any trial that didn't have that rule could ever have been truly fair. And we might disagree about which cases fall into the watershed bucket, but I'm willing to die on the hill that it's more than zero. Right, and that, you know, if Gideon is one, right, there can be others. Now, I think Crawford should have been one, right? I think Apprendi and Ring should have been two. The court said no, and then the court turns around today and says, because we said no there, that must mean there's no category. And that doesn't follow. You've totally lost why Harlan has this exception in the first place.
Okay.
Well, and also,
so
like,
all of which is a very good
hold on, I want to hear what Leah has to say.
my
really.
question.
Hold on, but I want to hear what Leah has to say. What are you going to say, Leah?
So I think what I might say might partially be responsive to your question, Ben, which is
It's
the
funny
idea
how all
of
these
like
responses predate the question.
Zeroing out the category of like watershed rules of criminal procedure displays, to my mind, a sense of hubris that is like borderline unconscionable for someone like looking around at our criminal justice system today. Like, imagine being a judge, seeing, you know, thousands, tens of thousands, hundreds of thousands of criminal justice cases and saying, this system is like humming along to such a degree that there are no watershed rules of criminal procedure that we have yet to recognize that will fundamentally alter our criminal justice system.
Right, it's not possible. It's not possible that there could be a new rule.
And like that, I just think that is like the wrong approach to thinking about the world and particularly the criminal justice system. And I think the prospect of there being some watershed rule of criminal procedure, you know, the existence of that possible exception, in an article by, I think it was Doug Fox and Alex Stein, they suggested that the existence of these exceptions partially worked as an incentive to states to get them to change, you know, their criminal procedures in order to avoid being stuck with the retroactive consequences of a constitutional ruling by the court. Once you take that off the table, then states no longer fear, well, like, if I don't change this and the court does it for me, then I might have to like eat the cost of this rule going back, you know, however many decades. That, you know, might alter the landscape of criminal justice reform.
Can I just add really quickly? I mean, the other thing is, again, I think it's worth putting these rules side by side. I don't think Ramos is of a piece with Crawford, right? And that's for two reasons. One, right, Ramos, we're talking about 2 states, not 52. Right, we still have courts-martial, right, that are trying people to non-unanimous verdicts, right? It's still, we have a system that still is doing this. Whereas Crawford is like a fundamental reconception of the Confrontation Clause that is based on the notion that you can't actually vindicate the Sixth Amendment without giving criminal defendants a right to cross-examine the individuals who are responsible for the formation of testimonial evidence against them. Why, if that's true today, was that not true 5 years ago? Or more to the point, why, if it's true today, is it true 5 years ago for the guy whose lawyers strung out the appellate process, but it's not true 5 years ago for the guy whose lawyers threw in the towel? Like, that's just not a coherent system.
Can I, sorry, Ben, I feel like you have a question. I just want to
anybody that saw it, they knew what they were getting.
I'm super fascinated by the degree to which an entire discussion in response to a question can precede the question. I love it.
So I just want to like add some additional dismay about the majority opinion in Edwards, which I feel like your question might not prompt. But while we're proceeding with the question, you know, I'm just going to go for it. There are parts of Justice Kavanaugh's opinion in which he suggests that Justice Kagan, who wrote the principal dissent in Edwards, was somehow not in a position to decide whether the rule in Ramos was retroactive because she had dissented in Ramos. This is insane to me. like the fact that Justice Kagan was in dissent and is now willing to honor that ruling and like give it all its worth and basically say, based on what the majority in Ramos said, this checks all of the boxes for a watershed rule of criminal procedure, is not a knock against her. It's a knock for her, because it suggests, right, that she is actually not kind of like on board with the whole Ramos project and like not wanting to push this rule on everyone. Exactly. But like viewing this from the perspective of, now that this is on the books, like I'm bound to fairly apply it and interpret it. And just was not there for that.
Ben, have we guessed your question?
Here's my question. Is this a situation that animates Fed court nerds like you guys, and is a really big deal in the sort of tectonic plates of jurisprudence and con law worlds, but actually doesn't affect the world very much? I'm thinking of the whole 11th Amendment line of cases that people like me made a very big deal about in the late 90s and early aughts. And, you know, I always found myself defending the proposition that they actually mattered to anybody but 30 people who represented either states or thought about it on behalf of, you know, for law review articles or for, in my case, as an editorial writer. Or is this a situation that has discernible impact for the way criminal cases are actually litigated, given that we don't have a lot, the set of rules that are fundamental rules of criminal procedure under the previous regime that are now a null set under the current regime? That set was one to begin with, and you guys, you know, Vladeck, you're saying, well, you know, I think it's likely that such other rules would exist. I can't tell how realistic, how real world a problem this is, and how much it is like something that will animate a lot of law review articles for the next few years, and, you know, we'll all talk about at conferences, but actually won't affect that many people.
So
that was my question.
Leah, go ahead.
So I would want to answer this question in at least three different parts. First is with respect to Ramos. Second, about a more general trend. And then third, about, you know, specifically the like watershed rule of criminal procedure exception. So first, with respect to Ramos, this actually will affect, or could have affected, at least a few hundred people, you know, within Oregon and Louisiana. So to my mind, like that's pretty significant, particularly when you add in the fact that non-unanimous jury convictions did result in a fair number of innocent defendants being convicted. You add on to that the fact that the non-unanimous juries were adopted in part in Louisiana originally as a way to make it easier to convict Black defendants in particular. And then you start saying, well, like, okay, even if this affects a few hundred cases, given the prospect that this, you know, involved, you know, racially tainted criminal convictions, like I think that is significant enough, you know, to care, you know, about, you know, even on the particulars of this one case, you know, and whether the rule should be retroactive. But second, I think that this decision is emblematic of a broader trend that is quite significant, which is the court is not really undoing the scope of criminal procedure rights. It is instead jettisoning the availability of any remedies to enforce them. So in this case, right, the court announces this like great new right in Ramos, and that leads to like all of this press saying like, is Justice Neil Gorsuch the new hero of criminal defendants? And like, wow, Justice Neil Gorsuch and Justice Brett Kavanaugh understand the relevance of race in our criminal justice system. But then like when the rubber hits the road and the question is anyone going to get the benefit of this ruling after they were convicted unconstitutionally? The answer is no. And this case is not the only case where that has happened. Instead, it is quite common when it comes to the scope of the exclusionary rule for purposes of the Fourth Amendment, basically whether illegally obtained evidence can be used at criminal trials. It is a problem when you're talking about suing officers for civil damages, and the court has granted them blanket protections for qualified immunity. So you can't get damages, you can't exclude evidence from criminal trials, you can't sue federal officers because the court is unwilling to recognize any cause of action against them. It's unwilling to actually grant habeas relief because it has interpreted, the scope of the Anti-Terrorism and Effective Death Penalty Act's restrictions on habeas to be so copious. Like, I could go on, but the problem is the court is not doing anything with respect to rights while dramatically undercutting remedies. This leads to a disparity where people don't necessarily understand. I think Carol Steiker called it the dissonance in the acoustic separation in the court's criminal procedure jurisprudence, where people think their rights are intact, but the remedies aren't going anywhere. And because people pay less attention to the decisions on remedies, this is a problem. So this is, the larger trend that I think this decision is emblematic of that is problematic. And then last, on watershed rule of criminal procedure, I actually think it's possible that this court could recognize some new criminal procedure protections. Like, I'm still holding out hope that this court is going to say it violates the Sixth Amendment to increase a defendant's sentence, for a judge to increase a defendant's sentence based on conduct that a jury acquitted them for. That would be a new Sixth Amendment rule that could be quite significant. But guess what? The court just said, no one, who had their sentence increased is going to get the benefit of it. And in a new future court, maybe there would be even more criminal procedure rights that, again, people who were convicted in violation of will not get the benefit of because of this ruling.
Can I just add two things to that? I mean, I agree with all that. I would just say the other piece of this is, states learn from these decisions, and what kinds of incentives is the Supreme Court creating for state courts to actually get it right, when, as Leah points out, they are increasingly facing no consequences for getting it wrong. And the second part of that, to the sort of, the thing that drives me most nuts about this decision is it wasn't necessary, right? That the court had wriggled out of declaring Apprendi retroactive, declaring Ring retroactive, declaring Crawford retroactive, without jettisoning the entire topic of watershed rules, right? Like it's one thing for us to fight over why we think Ramos was under Harlan's formulation of watershed rule. It's another thing for the court to say, we don't, and therefore we're also going to get rid of this whole category. Like, there's the wrong part of today's decision, which is why Edwards is not a watershed rule. And there's the "are you kidding me" part of today's decision, which is from this day forth there shall be no more, which no one had argued for, which of course is fitting because in Teague versus Lane, the court adopted this framework despite the fact that no party had asked it to, right? So, it's just, every time we hear people get on their high horses about how conservative judges call balls and strikes and stick to the law and don't reach out to decide issues not properly before them, I just want to bang my head into the wall, because the reality is they do it all the time. They're just, they do it in decisions that are not visible to the same extent as the more, sort of the decisions by progressive judges that provoke the same reactions in conservatives.
So I'm going to take this back to abortion because, well, one, I think that the point that you just made, I mean, there's only, I actually love that these are the two things that we're discussing, even though they're both super depressing. But I think that there is something very similar about the two cases, in that they just seem unmoored from they seem unmoored and inconsistent the granting of cert, as you said, Steve, the idea that there's no circuit split, that there's no need to take this case right now, that this is this is obviously like the some type of, I don't know, what is the term when you have when you have a mandate, like they feel like this is like the mandate of the court, except it's just, that's not how courts work. So that's kind of the whole idea. But not just the abortion case. I think that there's something that we didn't fully appreciate. And I guess I did. I remember being maybe more upset when Kennedy retired than when RBG passed away, because I kind of felt like the Kennedy retiring was much more like the finger in the dike than RBG was. And I'm wondering if that's something you guys that this is we're seeing this all kind of play out right now in these decisions.
So I don't. Leah's going to have a lot more to say about this than I am because she knows Kennedy so much better. I'm just going to go first because I have to go in a minute, and then
Yep.
I
Oh my God,
proactively
5:40.
endorse.
Holy cow, that was fast.
So I mean, Kate, I wrote in July of 2018, right, that people were not taking seriously how fundamental and paradigm shifting an appointment Kavanaugh would have been, and I think that from July to early September, right, that was the story about Kavanaugh, like just how far is he going to move the court to the right, and then Christine Blasey Ford, became the story, understandably. But so that by the time we actually got through that disastrous, episode, right, there was like nothing that we had forgotten the original story, which is that in every way that Kennedy had moderated the court, Kavanaugh wouldn't. And we saw that last term where all of a sudden the chief became the moderating influence only in cases where there were strong valences about the court's institutional role, right? And so we were already there, right? The chief was just a little bit of a speed break because there were things he would not do, even though he supported the substantive results. There are COVID cases on the shadow docket where he joined the progressives in dissenting, not because he agreed with them on the merits, but because he thought this was not the right forum procedurally to issue this kind of relief, right? He's the only one of the conservatives who does that. And so I think, the reality is that we were already heading in this direction long before last September. And that it's, RBG's death just accelerates this dramatically. Whereas I think it was, most of this would have happened anyway, right? But the sort of the two caveats are, one, now they have the votes to do lots of stuff, including on the summary docket, because there are 6 of them. And two, maybe if RBG had been replaced by a young, spry liberal, right, that would have actually incentivized some kind of moderation on the part of the chief of Kavanaugh. But I mean, guys, it is the Kavanaugh court now. I mean, that's, he has been in the majority in the most cases this term. And
that is an interesting, I did not know that statistic.
Yeah, and I think we're seeing what that looks like. And I think, at least to me in retrospect, this is not especially surprising, but that's not to say it's a good thing.
Oh God, so freaking dark. Okay.
Yeah, not to hop on like the "I told you so" bandwagon, but like right after Justice Kavanaugh was confirmed, right? I had a New York Times op-ed that said like liberals and the powerless should worry about the Kavanaugh court, right? And like what were the examples I gave? 1, abortion. 2, executive power. Guess what has come to pass, right? Like these things were obvious to like anyone who had been paying attention, and right.
3, habeas.
Yeah, right.
But that was my piece.
Yeah.
Watch out.
That's true.
Ben Smith's coming for you.
The New York Times wouldn't let me include that part. Obviously, I would have. But yeah, I mean, and like people just choose not to care, acknowledge reality, pay attention, some combination of all of the above.
And I think part of that is because if you look at last term holistically, right, the court didn't take the kinds of cases last year that would have provoked this kind of reaction for the most part, right? And that, the court mostly stayed out of the election, notwithstanding Kavanaugh's votes repeatedly with the other conservatives to be more involved in the election, right? And so, Kate, I think this is the court we've got. And I think, I am not a strong supporter of Supreme Court expansion, but this to me is like, I mean,
I thought I had a tough run of it covering Facebook for a living, and you guys have to now. You guys are stuck with these yahoos.
Well, not just covering it, Kate, but practicing before it. I mean, the way that you structure arguments to try to appeal to this court, right? Versus as recently, I mean, Leah and I were co-counsel in the Hernandez Bivens case, where we filed our cert petition 2 weeks before Kennedy announced his retirement. And the cert petition was like, hey, Justice Kennedy, this is the perfect case for you. This is exactly the small potatoes case where you can show that you're not willing to get rid of Bivens. And then he retired, and Kavanaugh's like, right? So, I realize I'm personalizing it because I'm bitter, but but this is, I mean, it's just in cases small and large, right? This is sort of, and I don't mean to pick on Kavanaugh. As Leah points out, like this is not a surprise to anybody. right, who knows him and knew his jurisprudence on the DC circuit. It's just that like other things had sort of drowned out that part of the story for the better part of 2 or 3 years, and now we're finally seeing it come to pass.
Yeah, like if you want to read a real I told you so, read Melissa Murray's testimony against Kavanaugh's confirmation, in which she says, like, Justice Kavanaugh may be charming. I have had lunch with him and he is nice, but he is going to gut abortion access.
Yeah, it's
all right. So on that happy note, friends, I got to go tend to my kids.
Steve, so fun to hang out with you. Thank you for coming.
Good to see you, Mr. Vladeck.
Thanks,
and I'm going to bring in one of my former students, Genevieve, who's a big fan of who is a big fan of yours, Leah. And as Steve takes off, and has a string of wonderful questions. And Genevieve, go ahead and read whatever ones you want.
Oh, thank you. I got a little carried away in my questions. So the first one is, much has been made of like Justice Barrett's opinion of stare decisis, and like the little I've read of her scholarship, she seems to be less hostile to it than in the news cycle may portray. This seems more like legal realism in a lot of her writing that I've seen. Do you have any opinion on this?
So it's a little bit hard to compare her to someone like Justice Thomas, who has written about exactly like when he thinks stare decisis is unconstitutional and when he hasn't in his capacity as a justice. So Justice Thomas has famously said, right, he actually believes it violates Article 3 for a judge or justice to decline to overrule a case if that case is demonstrably erroneous. And he has made clear that he believes, Roe and Casey are demonstrably erroneous. In her academic writings, Justice Barrett also shared the idea that in some cases, stare decisis is unconstitutional because it requires judges to adhere to a wrong, account of the law. Now, it's not clear in exactly what set of cases she would say there are sufficiently important countervailing considerations such that a judge can adhere to a wrongly decided case. So it's a little bit hard to compare her to Justice Thomas, but it's also the case that no other justice has suggested that adhering to a prior case because of stare decisis considerations might itself violate the Constitution. So she's already, right, further against stare decisis than like any previous Supreme Court nominee has been. And I think that is what the news cycle and commentary is picking up on.
Okay. And then I'm going to ask one more. Thank you. Is it like slightly naive to be optimistic in any way that the court would act more conservatively on this issue? And when I say this, my ideal circumstance here is they granted it to slap it down just simply because so many of the states seem to be pushing these challenges towards a court that they believe would be sympathetic to an abortion challenge. And I mean, Justice Kennedy did have a lot to do with Justice Kavanaugh's nomination. So I'm just trying to find something optimistic.
Yeah, so I think the problem is there was no reason to take this case and slap it down, right? Like the biggest signal that they're not interested in this at all, right, is to like not take the case and just signal like we truly have no interest in like revisiting the law of abortion entirely. So, I don't think there is a ton of hope to think that this court is going to use this case as an opportunity to reaffirm Roe and Casey. I think the only question is like, how much are they going to change them? And, that is, I think, the question that, I don't know that anyone really knows the answer to at this point.
Yeah.
Okay.
Thank you for your questions, Genevieve.
Oh, thank you,
congratulations being done with finals.
I'm so happy.
Congrats.
I'll talk to you soon.
Bye,
guys. That was great. We have one more question from Lauren G. bringing in, which I think is a fascinating question because it is about kind of maybe what we start working on next if all hope is lost in the courts. And so, Lauren, please, I'm so happy to have you here.
Thank you. Is my mic working?
Yeah, we can hear you perfectly.
Okay, because a minute ago it had a slash. And I'm sorry if you've kind of gotten around this question. I'm still working, so I have to keep dashing back and forth on my computer. But so if they restrict or pretty much strip Roe even further, is a recourse, how do we get it back? I mean, does it have to be a court thing or is it a Congress thing?
I think it can be through Congress or the courts. So you can imagine a world in which Congress passes a statute that codifies, a right to abortion and purports to prevent states from prohibiting abortion, before viability or enacting various restrictions on abortion. I think the concern with that approach, however, is it's not clear whether the current court would say Congress has the authority to enact that statute. In a lesser known decision in Bernie versus City of Flores, the court said Congress's powers to enforce the 14th Amendment were basically restricted to prohibiting state laws that a court would say violates the Constitution. So if the court comes along and says it doesn't actually violate the Constitution for states to restrict abortion rather substantially, including pre-viability, then this court might say, well, Congress doesn't have the authority to prohibit a bunch of state laws that the court would say is constitutional. Now, a bunch of people think that Supreme Court decision that narrowly interpreted the scope of Congress's powers to enforce the 14th Amendment was wrong. I think it's wrongly decided. Michael McConnell at Stanford thinks it's wrongly decided. So
Michael McConnell, the conservative
Yes.
former 10th Circuit justice, who's now a professor at Stanford, just to give you it's you're in good company. There's
on the oversight board.
Yeah, on the Facebook oversight board, whatever. But yes.
Yeah, so it's possible, that you could get the court to revisit Bernie. I think it's extremely unlikely that this court would do so if the case that made its way to the court were a statute that purported to protect access to abortion. But, so that is one possibility, although it is a possibility that could run into problems with the Supreme Court and this Supreme Court in particular. The other option is you get a different Supreme Court, and that different Supreme Court says, actually, the right to abortion is protected after all, like we said in Roe, notwithstanding what this said, but that will take something that the Democrats are unwilling to do or 3+ decades.
I want to propose a third alternative to that, which is a congressional enactment based on a different constitutional theory. So I'm thinking about a commerce power law. It would have to be strangely worded, but it would say something like, no state except, put in your Roe Casey language here, shall prevent any provision of service using instruments that have traveled in interstate commerce, for the termination of a pregnancy by adult woman who seeks voluntarily to terminate a pregnancy. So you root it in the congressional authority to regulate interstate commerce and to prevent states from interfering with interstate commerce. The commerce is not the abortion itself, but some combination of the abortion, the medical instruments, the payment systems, the insurance, the using any, and I cannot see how after the second Gun-Free School Zones Act case, where all Congress had to do to get the original Lopez decision overturned was say a gun that's moved in interstate commerce, and all of a sudden the Supreme Court is jello. I don't see how that does not provide. It's an emotionally less satisfying for people who want this to sound in fundamental rights rather than in Congress's authority to regulate interstate commerce. But if I were advising the House or Senate Judiciary Committee how to do this in a way that had most likely 5 votes in the Supreme Court, it seems to me the commerce theory is stronger than the 14th Amendment jurisprudence.
So I think the commerce theory is strong in the sense that, under current doctrine, right, that should be obviously constitutional, but still not without problems to a point where, I'm not confident that there are 5 votes on the Supreme Court for the proposition that statute would be constitutional. And why do I say that? One is the court has said that the commerce power allows Congress to regulate individuals and not states. So to the extent that the purpose or effect of that statute would be, to restrict the laws that states can pass, then you would be confronted with a problem about whether the statute actually does, regulate private parties, right, and grant them rights or immunities or obligations in such a way that it validly preempts state law or commandeers them. That was the line that the court adopted in Murphy versus NCAA. And I actually think that line, is right in some ways, but it's also difficult to administer. And whenever you encounter like a difficult to administer standard, like that's going to give the court some wiggle room to say, well, actually, we think this statute falls on one side of the line, even though other statutes that look similar, do another. And the Gun-Free School Zones Act, which you mentioned, Ben, and for listeners who might not know, in Lopez, the court struck down a federal statute that prohibited gun possession near schools. And then Congress came back and said, you can't prohibit a gun near schools if the gun has traveled in interstate commerce. And every court of appeals that has decided, the question has decided that statute is perfectly constitutional and the court hasn't said a thing about it. So that statute just flat out prevented private parties from doing something. The statute that you're imagining is purporting to like grant a right to private parties and basically like immunize them from state regulation. And that's like a little bit different in a way that potentially implicates the 10th Amendment. And then even though like I think, that statute, again, perfectly constitutional under current doctrine, like nothing stops the court from altering current doctrine. Like that's what they're about to do in Dobbs. And like, we don't know if they would say, well, there are some limits where we're dealing with, sensitive areas of like state concern or traditional areas of state regulation or like whatever you want to say, that they would say like that statute just falls on the wrong side of.
So this is great. I don't want to I think that's actually like a really good place to leave it. But I will just say that that there is something about this I used to beat myself up as a law student doing con law. I took 6 con law courses, I think, in the course of and you wouldn't know it because I don't go near the stuff now. But one of the reasons is because I found this to be so philosophically disappointing. The legal realism of it to be so bordering on almost nihilistic. You hope that this institution stands by its precedent, and then it doesn't. It decides.
Oh, it's not a real court.
It's not a real court. I know. And then then I come up with then I do what I do now, and everyone's like, it's not a real court. I'm like, what the fuck is a real court? Who the hell? No.
Once you get used to the idea that it's a play court that's designed.
We are talking about the actual Supreme Court now.
Yeah. That it's a toy court designed to give Leah and Steve things to write about and get upset about and get thrilled about. That's its actual function, and that it's it's a combination of a political plaything and a political plaything that matters a lot because it defines law for other people and real courts. Once you get used to that, it upsets you less.
But bless you, Ben, because that is exactly it is a play court that has real implications and power implications on real people, and it plays
the opposite of the oversight board, which is a play court that doesn't have.
Anyways, I don't want to even start with that, but I just Leah, thank you for doing the hard work on these things. Thank you for always being willing to come on the show and explain this to people. That was an incredible conversation with Steve. I feel like we all learned so much from you. And just as a note about kind of a little bit as I've studied a lot of second generational feminism and first generational feminism, but in particular, where we've come from Roe, the right for people to control their bodies is so fundamental, and we lose sight of it in these tiny little breakouts and these tiny little conversations. And so I just really want to say that my right to birth control, my right to abortion as a woman changes fundamentally who I can be and what I can do and how I can live my life and what I can give back to society. And it is a societal good. And I just really feel that is something to keep in mind when we're talking about what we're fighting for, that it's not about trying to go after children or something like that, that there is something else that's really worth fighting for here, which is about women's ability to contribute to society and to have their own ability and their own voice and space for these things. So anyways, that is where we'll leave it. It is 6 p.m. We will be back 20. Wait, hold on.
You have to tell Leah Litman she's a great American.
Oh, Leah Litman, you're a great American.
Thank you.
Otherwise, she might get offended when she sees the ends of the 415 other shows we've done.
In which Scott Shapiro was on and I wasn't. No, I'm just kidding.
That's not a
Hey,
lot
if
now.
you want to host a day a week, get in touch.
I
My
know.
tenure file isn't closed yet, so I don't have that luxury.
I hear you, sister. But
Well-
yeah, we will leave it there. We're going to be back 22 hours and 59 minutes from now. Leah,
I'm
Litman,
not.
Great American. Oh, you're not coming on with. You're not coming on.
No, this is you and Scott Day. This
Oh, it
is like
It's with,
I get a
we're
day
having
off.
Julian Mortensen and Nick Bagley on.
I love them both.
Yes,
and
Leah's
Julian
cohort.
Mortensen has the best. At least he used to have the world's greatest Facebook icon, which was a little Lego.
Oh yes.
Stormtrooper throwing
Oh,
a
he
baby
still is.
Lego stormtrooper in the air. It's
Wait,
beautiful.
doesn't Julian also have your like dog cousin or something like that?
Yes, so Julian Mortensen has a dog that is actually the half sister of my dog.
I love
Wow.
that. Stevie's the
This
best.
is what happens in a small university town.
I
No,
love it.
we got our dogs in Florida.
See,
With
interstate
a sister
commerce.
city
Interstate
relationship
commerce.
with Florida. We will be back. All of that will be 22 hours and 58 minutes from now. And until then, we don't have fun anymore. But for now, for maybe the next 11 and a half months, we still have Casey as the law of the land.
Oh man, that was a dark way to end it, Ben.
Yeah.
Goodbye.
That's the best I can do.
Goodbye. Bye, everybody.